minister. And
it's not been, there's been no joined up issue on the accuracy of that in this case.
No, Your Honor. And we would say that report also shows, demonstrate conclusively that the decision was taken prior to whatever the review process that was promised or that ought to have been done, which offends the basic notion of how consultation ought to be conducted. It simply could not happen after. There are two other, just factually by way of timeline, by way of conclusion to the factual background, and I'm almost done, that Mr. Fraser, who was appointed by the government, first engaged the applicants in March 2016 to establish a timetable for submissions. This is prior to the airport renaming, and invited the applicants to make submissions on June 30th, 2016, or with oral submissions on July 8th, 2016, and a report was completed on October 3rd, 2016. During that period, on May 9th, 2016, the airport was renamed, so certainly the minister could not have had the benefit of Mr. Fraser's report, regardless of what it may have revealed or not. Certainly the process...
that invitation to meet with Fraser in March 2016, is this in writing? Is this to be found somewhere in the record?
This is to be found in the Fraser report itself.
Okay.
When he goes through what process he followed. And the Fraser report is to be found at page 458 of the record.
Mm-hmm.
And on page 469 of the record, Mr. Fraser relates NATA made oral presentations on the 8th of July 2016 in its initial submission in a memorandum dated June 30th, 2016, and so on and so forth. Those dates are memorialized in his report.
Okay.
So, separate and apart from that, just to quickly address what some of the arguments are raised in my friend's answer.
Sorry, but before you go to your friend's answer, Mr. Kisun, the consultation which you say should have taken place, what, in essence, do you require to have taken place by way of consultation? What do you say should have taken place?
What should have taken place was that the appellants should have been allowed to express what their concerns were concerning the airport. Those concerns ought to have been received and considered, and then a decision ought to have been made.
Yeah, all right, good. The reason I ask is, it seems to me that in the press, as well as in correspondence between the parties, it was made abundantly clear to the minister what the concerns of the other airport operators were. I have looked at the withdrawal, for instance, by Air Services Limited, where they rescinded their support for the renaming, a letter of 23 October. I have looked at a letter of the 5th of November by Wings Aviation, where they rescinded their support. And then I've seen that beginning the 28th of October, Roraima and 6 others objected. Hinter did it, Oxford did it. So they all stated in writing their objection and the basis for their objection. So I'm wondering what information by way of consultation was not put before the minister so as to, on your thesis, vitiate his decision making or to establish that he did not consider the things that a sit-down consultation would have disclosed to him?
Colloquially, the impression I've always gleaned from this case is that the operators were seen as making a mountain out of a molehill. Mm-hmm. However, in speaking in detail with the operators explained to me, by way of market study, for example, a market study was commissioned as to what the impact of the brand would have had, that there were certain substantive issues that could not be captured by a very brief letter. And the operators felt that those evidential and that factual impact as to what the airport renaming could have and has on their business, if that were properly presented to the minister would have had information that was sufficient that may have persuaded him to come to a different conclusion, may or may not. But the fact that the minister is aware of the issue, it's our respectful submission, is woefully inadequate in light of the complex competition and historical issues dealing with the management of the airport. The applicants don't believe that the minister at that time, in making the decision, had the facts before him and had not considered those facts. So complex were the facts that the minister sought it prudent to hire an independent person to review the issues. And if you read the report, the independent person's review doesn't yet come to the conclusions on the substantive issues. In other words, it requires a large degree of factual scrutiny.
With respect, Mr. Kisoon, what troubles me here is this. The supporting material that you are saying the minister could have received, should have received, and could have benefited from, could only support the proposition that the anti-competitive impact of the renaming was vast. If the minister was clear in his head that this was the situation, I'm just saying, I'm exploring hypotheses. If he was clear that that was the case, then the fact that he did not see the detailed evidence in support, does it make any difference? I see, for instance, the Court of Appeal mentioned that you submitted a 1,000-page documentation, which they had to wade through and that they could have done without it. Essentially, I think making the same point that the claim of doom and destruction, they essentially said was not made out, but more, I think, significantly, that this claim, whether made out or not, was simply the support for the basic proposition that if you rename this airport, you are playing into Correia's hand and you are giving them a huge advantage over us.
Mr. Kisoon, if I may, just benefiting from my brother Justice Barrow's intervention, the Court of Appeal seems to be making a very fundamental observation in respect of your case. They're basically saying that this, if you look at page 41 to 42 of the record, really is the Court of Appeal's judgment. They said, and I quote, "It is the view of the Court of Appeal, in the view of this court," let me begin again. "It is the view of this court that the applicants appear to have grievances with the Correia Group and are attempting to use public law proceedings and remedies to address private grievances." This is a complete denial of any breach of a duty to consult. It seems as though the Court of Appeal is making this fundamental claim. Do you want to comment on that? Because that, if it is true, would be the end of the matter. Do you want to comment on that?
Well, there are some operators that by virtue of their lack of market standing or non-involvement with the management and control of OAI simply don't have any other cause of action that exists in private law.
Sorry, but is that true? What about under Section 224 of the Companies Act, the oppression remedy?
6 of the applicants are not shareholders of the company.
But you don't have to be a shareholder. It's a complaint. You just have to be a complainant.
Well, I'm guided where that's concerned, but they would not. We would respectfully submit that they would not have sufficient standing to deal with the management and operation of this private airport entity, and accordingly, they're not afforded a direct cause of action against OAI. They don't have a sufficient market share to file a competition complaint against OAI, and here we have a process. Though the outcome may be the same, which it could very well have been, a process which clearly was not followed and did not conscientiously consider the applicant's views, because it couldn't have done so because it didn't have the material. The decision maker didn't have the material before it.
If I may quickly, then, are you agreeing with the Court of Appeal that absent appropriate grievances procedures, private law grievances procedures, that you turn to public law to remedy that situation? Is that a proper use of the public law remedy of judicial review?
Well, I think there is no adequate remedy in private law here. So yes, it's our respectful submission that this is a matter that's ripe for judicial review concerning the issue to consult, and the focus, of course, is different. What one seeks to impugn is the decision of the minister. The decision of the minister could never be impugned in private law proceedings. There's a different end to it. In private law proceedings could be the conduct of OAI in making the request. But it's our respectful submission that they're 2 totally different things. It's not that we are seeking the same relief that we could have sought against the same entity in private law proceedings. There is no relief against the minister in private law proceedings. So we respectfully disagree with the Court of Appeal in saying that there was some sort of alternative remedy. I think what the Court of Appeal may have done respectfully, and it's my respectful submission, that they may have perhaps considered that if the end result could have been the same, then there's an appropriate alternative remedy. And we respectfully submit that that's not so. We have no other remedy against the minister. The remedy is against Ogle Airport, Inc. If we had standing, for example, there's nothing we could have done with respect to this issue. And just dealing with, just to address Justice Barrow's concern, we would respectfully submit that in any event, even if the outcome would have been the same, it could not be that that would be the end, because the process would have had to have been followed. And we would submit that as a matter of law, that quite simply, we weren't given full satisfaction of the gunning test, which established the 4 prongs that was necessary for the duty of consultation to have been discharged. In other words, there wasn't consultation when the proposals were at the formative stage. Adequate information was not provided in which to respond. There was not adequate time in which to respond, and there's no evidence of conscientious consideration by an authority. But really what we have here are appellants that are asking for a remedy so that they could be heard.
Mr. Kisoon, what is the document by which the change of name was formally effected?
The document that the name change is formally effected is called a airport. Sorry, I have it right here. Forgive me. That document that would have been issued by the Guyana Civil Aviation Authority is not part of the record. However, there is a letter that is written by the Guyana Civil Aviation Authority which stated that the minister had approved the airport name change.
Yeah, I have seen that, but sorry, would counsel on the other side object to that formal document? That's in the nature of a statutory instrument or something?
No, please, Your Honor, we wouldn't object. It shouldn't be by order.
By a formal, as it were, legislative
No.
subordinate. No. Anyway, Mr. Hawk does not object. So hold on, Mr. Kisoon. So perhaps you could let us have it. The formal document which changed the name. Hello.
I suppose there should have been an Aeronautical Information Service notification.
That's correct, Justice Smith. That would have been the only document that would have been dated if an effective date, which is not on the record, similar to what was issued on October 20th.
And I have gotten from Mr. Hawke, he would not object to your furnishing that document. So I'm asking, could I ask you to please furnish it to the registrar of the court?
Or if maybe the Attorney General, whoever has access to it, if it's not a document that the parties got, because it would be a document that the state or some organ of the state would have issued under the imprimatur of some officer of the state, I imagine.
Essentially, what is being asked of the High Court is to quash that the decision and consequently the order following the decision. So I think we should see the document.
Your Honor, at your leave, if I can undertake to have that document conveyed to the registrar of the court.
Much appreciated.
Yeah.
Okay. Thank you. Now, Mr. Kisoon, are you saying now that it would have been okay if the minister just had waited for the Fraser report before he approved or disapproved?
It may have been if the Fraser report did not consider the issue of the airport name change, that may have given rise to a separate issue. But yes, it could have been that he would have just had to wait and then make his decision.
But I think your client sent the first submission to Mr. Fraser on the 30th of June. I suppose that also mentions the name change and why it's bad.
That's correct. Yeah.
Yes, and there was an oral presentation on the 8th of July.
That's correct.
And that issue also came up in that presentation?
I don't know. That I don't know.
And on the 13th of July, there was a supplementary memorandum. Did that mention the name change?
I'm not sure.
You're not sure? Okay, so, well, we know now that Fraser did not really tackle the name change in his report.
That's correct.
That's correct. Okay, but you, if that report would have gone to the minister, he would have had not any recommendation from Mr. Fraser, but he would have had the full force of the objections from your clients.
That's correct.
Yes, and of course it would still be possible for him then to say, well, despite these objections, given everything together, I still approve. That he could have said that.
Absolutely.
Yes, and in such a case, it seems to be difficult to find procedural unfairness.
If that procedure was followed, yes, there would have been. That would have been the end of the matter.
Okay, and so you would want us to say that well, how the minister proceeded was not proper, and therefore, what would you want us to do to say that the name change was
to quash the minister's decision to give approval of the name change?
Okay, so then it would go back to the government.
to consult with the appellant.
And then either to approve or disapprove.
That's correct, Your Honor.
Okay, but in the meantime, given the delays, the name of the airport is already since 2016 what it is now.
Yes, that's correct, Your Honor.
Yes. Okay, well, that's clear. Thank you.
And just to conclude on that note, we respectfully submit that the matter is not academic. All it's required is a rescission of that aeronautical certificate, as was done in October 30th, 2015, and the name change would simply be effected. There is a real remedy that the appellants can obtain, and of course, it was always contemplated that this was not a fait accompli, even by the press interview that was given by the minister.
Because, Mr. Kissoon, you had acted fairly promptly, I gather, after the name change. Hadn't you sort of brought a motion for an emergency or urgent hearing?
Yes, Your Honor. We brought an emergency judicial review proceeding, and when that
within a month of the name change, right?
Within a few days of the name change.
There you go. Right.
And then we filed, within a few days of being denied, we filed a notice for urgent appeal, an urgent hearing, which was not heard for until a year later. And when that motion was heard, the appeal was not heard until a year and a half after that. And
but the decision was given 4 years after the motion, wasn't it?
Yeah.
Well, the decision
in 2020 of the Court of Appeal. The appeal was decided when? In 2020, wasn't it? July?
That's correct.
Well, there's nothing more could have been expected of you, because you seem to have acted with quite some dispatch, as I read the record.
Yeah, that's correct, Your Honor. We were not negligent in that regard, because we understood that we would have been foreclosed from seeking any remedy for that basis. Unless there's anything else, I respectfully close.
Thank you very much, Mr. Kissoon.
Thank you.
Mr. Hall.
Obliged, Your Honor. Your Honors, the premise of our submission is on the basis that there was a clear, unanimous decision by the Ogle Airport Inc. Board approving the name change. And I should pause here to say, the suggestion of a name change was intimated by the then President Granger, as he then was, on an occasion for the commissioning of an aircraft. It wasn't that Ogle Airport Inc. Board moved to have a name change under Section 24, Clause 24 rather, of the lease. This was an intimation by, or a suggestion rather, by the then president, which was acted upon by the Ogle Airport Inc. Board. And the intimation of the board was that the decision was a unanimous one. We concede and we accept factually that there were concerns by certain operators within the sector, and those concerns from the evidence would have been raised with the Ogle Airport Inc. Board. And Your Honors, with your leave, just for completeness sake, the letter intimating that the board took the unanimous decision is at page 3 of 5 of the record. And that letter was dated the 14th of October 2015. It was written by Mr. Michael Correia. The letter of the 28th of October 2015 gives a clear indication also that there would have been objections. A letter would have been written by Captain Ali in relation to Air Services Limited, intimating that the shareholders had certain objections he said that he had certain reservations, but he will yield. Those were the words used in the letter. He will yield to the decision of the board. Subsequent to that, from the chain of the evidence, several other operators. Sorry.
Counsel, sorry.
Sorry,
if I may, all of this is going towards your submission that the decision was not unreasonable and irrational. Am I reading you correctly?
Yes, please, Your Honor.
But is that what is being contended on the other side? Isn't the other side contending that other judicial review or natural justice principles are being breached? Is the other side saying that the decision was unreasonable and irrational? I didn't get that impression.
Your Honor, if I may, with your leave, when one looks at the notice of appeal, the specific grounds as alleged by the appellants, their position clearly seems to indicate that the decision of the minister was entirely unfair and irrational. I accept the fact that my learned friend who's representing the appellants is attacking the decision on the basis of the issue of whether there was a legitimate expectation created, and two, at a minimum, as he said, whether there was sufficient consultation. But when you look at the chain of events, and
just a minute, but a legitimate expectation that they would be consulted. There are two limbs to it, as Justice Anderson raised. There is whether or not there is sufficient evidence to ground a promise to consult and therefore to constitute a legitimate expectation, or at a lower level, so to speak, whether or not the known circumstances were such as to create in the decision maker a duty to consult. So yes. I think that is what is before us, is it not?
Yes, please, Your Honor.
Yeah.
And our position with respect to the first limb is that on the face of the evidence, there is no express promise. So I want to make that submission, that full submission, that there's no express promise made by the minister. And I'll move quickly to the second aspect of it, the question of consultation. That seems to be the issue that my learned friend is pinning his submission on. And the issue that is before, that was before, those issues that were before the ministers are issues, as I would submit, the minister was brought aware of by means of the several letters written, and occasions indicated that these issues and concerns were raised, and we would submit actually considered by the minister, and the renaming of the airport proceeded. And I think the minister premised his decision on the fact that the two letters I was referring to, the one dated the 28th of October 2015, and there was a subsequent letter where Mr. Correia indicated in reply to Air Services that the decision was made and the board was not in a position to recant their position, and that they were proceeding with the renaming. It was on that basis that the renaming went ahead. So on the face of the evidence, Your Honors.
All right, just a minute. Mr. Rook, let me ask you something, just so that I can understand you. Are you saying that if the Article 24 requirement, that is to say that the operator, through a legitimate board meeting, requested a name change, that once that was done as a question of public law, a duty to consult could not arise? Is that what you are saying?
I'm not saying that, Your Honor. I'm not saying that. if I follow what my understanding of what also the Court of Appeal was concluding was that one, the procedural requirement was that under Section 24, Clause 24, the operators would make an application for a name change. What we know is that that was not the protocol that was followed. An intimation was made by the president, and I think on that basis, they then moved to follow what he was suggesting, which may perhaps bring you within the fold, if you want to argue generally, of Section 24, because Clause 24, because it would be the board, Ogle Airport Board, who would then be making the suggested name change in the end. But I'm not saying that it was not a duty to consult. What I'm simply saying, the simple submission I'm making, Your Honors, and I know it is not, if I can put it this way, at a minimum, not at the highest tier of what may be considered as procedurally fair. What I'm simply saying is that the minister, on the face of the evidence, it seems to suggest that the minister acted on the basis of a letter written by the chairperson of the board intimating that this was a unanimous decision of the board. I accept.
Mr. Hope, part of what I'm struggling with is what our brother Justice Burgess asked you, That goes to rationality and reasonableness. In other words, it is rational because there was an Article 24 request and he acted on it. It is reasonable because it is not unreasonable if a board under the statutory regime can make a name change and makes a name change and the minister abides. So yes, I think that is what our brother Justice Burgess was trying to clarify. What we are about, I think, is something slightly different. Now, what our brother Justice Barrow raised, which is where I thought you were going, and I'm just trying to be clear, that there's no duty to consult on the facts in this case because the minister had all the relevant information, and our brother Justice Barrow has particularized that very conveniently for all of us. Is that what you're saying?
That is precisely the submission I'm making.
Okay, right.
Okay, you're not.
The other possible submission you could have been making is that, there was the duty to consult, but it was in fact fulfilled because the minister had all of the information available to him. Can you just clarify for us what is your position? Is it that there was no duty in the circumstances? Or was it that there was a duty, but it was carried out?
I'm not saying that it wasn't a duty. I'm saying there was a duty, but in the peculiar circumstances of this case, we're simply submitting that the minister had before him all that was necessary to make an informed decision. And that is what the minister purported to do.
The other side, as I understand it, is saying that at least some of that information the minister would usefully have before him may have come through secondary sources. And they wanted to have had the opportunity of giving that information in a first-hand way so as to impress on the minister in a personal way the adverse effects of the renaming of the airport on them, so that the access through the secondary sources, according to them, was not sufficient to fulfill the requirements for consultation, because the consultation required them to have the opportunity of personally indicating in a fulsome way, a very detailed way, the adverse effects upon them of the renaming.
I understand. Sorry, Your Honor. I did not get your last statement.
We're listening to you, Mr. Hawk.
Your Honor, sorry, I thought you were making a final point. I interrupted you.
No. I've made a point. The point is that the appellants, as I understand it, are drawing a distinction between what the minister may have been able to gather from secondary sources, whether reading the newspapers or elsewise, on the one hand, and on the other hand, being able to have a meeting with the minister in which they were consulted on, if you like, face-to-face basis, where they could explain in fulsome terms the adverse effect they contend that the renaming would have had on them. And what they are saying is that they never had that opportunity.
So, Your Honor, if I may answer it this way, putting it at its highest, the question is how we address the issue of consultation, because if what is it that the applicant is seeking just to meet with the minister to put what they put before the minister by way of letters, or was it something different that they were going to indicate to the minister? From what we understand from the state of the evidence is that all that the appellants wanted to say to the minister was put before the minister. I think there's even an intimation that issues were raised at some time, at some level, in relation to the Fraser's report, albeit that report in its conclusion did not address the issue of the renaming. So I'm simply saying in the wrong, Your Honor, that is it that the applicant is saying what we wanted to say to the Honorable Minister would have been better appreciated by means of a actual physical meeting rather than issues, the same issues being raised, for want of a better term, on paper. And we submit, our submission is all the issues, whether you say, the applicant, the appellant say it would have been better by way of a personal meeting, we say the requirements of consultation would have been satisfied by means of these letters that would have been put before the minister, raising all these issues that they had concerns about.
Mr. Hawke, if things had gone the way you are saying, then wouldn't that have been logical that when the minister gave his interview to Stabroek News, he would have said, oh, but I already consulted. But apparently he didn't say that. He said, no, they are going to be heard about this change of name. I gave it to Mr. Fraser or independent legal counsel to deal with that. Now, if it is true what you said, then I would have expected him to say, well, we already heard them, and I didn't think their arguments made much sense, and therefore we already approved, and that's why the name change is effect, because in May it was already effect that the name had changed. So how do you explain that those words of the minister in May to Stabroek News?
Your Honor, I hear the question, and my response to it is that it accords with the minister's conduct and position, accords with the general principle of fairness. The minister was clearly intimating that even if there was, I consider the issue and there was a name change, I am still prepared to look at your concerns. I think that was the stance the minister was taking, which I would respectfully submit was fair in all the circumstances. And if I can use the term, Your Honor, with your leave, it's almost as though the minister was saying what I had before me, and albeit I gave a renaming of the airport, it wasn't cast in stone, so to speak.
So I think what the president is raising is, can we look at the language used, because there's a specific quotation, and I think we have to be careful how we choose to interpret it. What was the language attributed to the minister that's not disputed in this case? Can you remember, Mr. I think Eugene pulled it up for us. You have that? Can you turn up that report? The second paragraph has the quote.
I might have to ask my friend's assistant. I don't think I have, but I recall the gist of it was that the minister was intimating there's a quote from a press conference. The minister was intimating that he agreed fundamentally, I'm paraphrasing, that in fairness, the issues raised by the appellants in this case should be looked at. And he undertook, in a sense, to look at those issues. And I will use the term loosely going forward. But I'm subject to
well, if the minister thought that he had to, in the future, look at the issues, how do you hold that in balance with a submission that says the minister, you remember, under the duty, once you reach the point there was a duty to consult, then do you subscribe to the four-pronged framework of consultation that Mr. Kissoon spoke to? Because as long as you reach there was a duty to consult, then the question becomes, what are the requirements of consultation and were they satisfied in this case? That is a mixture of law and fact.
Yes, Mr. Honor.
But this, yeah, anyway, all right, we look at it, I suppose.
Mr. Hawk?
Yes, Mr. Honor.
The extract from the Stabroek News does contain a clear statement by the minister who says operators who oppose today's renaming have complained that this act will give an unfair advantage to a specific operator. Their concerns cannot be dismissed as something without merit. Therefore, this will also be addressed during our review process, Patterson said last evening. He said the concerns raised have not fallen on deaf ears and that the renaming would not drive the final nail in the coffin of those who feel that they have become disadvantaged. So Patterson is seeming here to be saying, yes, the renaming has taken place. We have considered the concerns that they raise about the unfair competition, etc. We do not take it as lacking merit, etc. But Patterson, it seems from this, is saying that their concerns have been considered. Isn't that what is being said here? Hello?
Mr. Hall?
You're muted.
Sorry, Your Honor, sorry. Sorry, Your Honor. I was just intimating that if
That noise, I don't know where it comes from.
I'm not sure where the noise is coming
Sounds like an aircraft.
Sorry, some work is taking place next door, so I'm not sure if I can help. I will mute my microphone. Drilling, apparently, yeah.
Yes, I was saying, Mr. Justice Barrow, that from the language of the letter, it would seem to suggest that the minister was basically intimating, contrary to what I was saying, that he took into consideration the matters, and his view was that the decision would be made because he was clearly satisfied, notwithstanding all the complaints that were put before him, that it was proper to rename.
So he was suggesting, okay, well, I took this all in consideration. I took the decision not to disapprove, but things may change after we have seen the Fraser report, so to speak. And they didn't change. Correct?
But unfortunately, Your Honor, the Fraser report apparently did not address the issue of the name change.
No.
It would seem as though the Fraser report was primarily based on the lease, issues in relation to the lease.
Sorry,
Sorry, please, Your Honor.
Mr. Hawk, sorry.
Yes,
Am I
Mr.
being heard?
Honor.
Yes, sorry.
Yes, Mr. Honor.
Yeah, I believe that the court would still benefit from an answer by you to the question raised by my brother Jamadar. What was read suggests that he might have heard from what sources we don't know, and that he took those things into consideration. Does that amount to consultation? I think that that's the force of the gravamen of Mr. Justice Jamadar's question to you. Would the fact that the evidence or whatever may have been before him, would that be a substitute for consultation, or would that constitute consultation? That's the question which I think my brother was raising with you. And I don't know if you've answered it, but I don't think that I understand the answer. If you've answered it, I don't think I understand the answer. If you could just repeat it, please.
I apologize, Your Honor. My submission on that is, and I'm going to repeat what I said earlier. It seems to me that there's a leaning of my learned friend that the issue of consultation has to be addressed on the basis of a physical meetings with the minister to address the issues of concern, as opposed to issues of concern being addressed by way of written indications. And our submission is the written indications would have been sufficient, and the minister did consider those written indications. And to answer your question directly, I guess, is to say yes, that the concerns that have been put before the minister would have met the issue or the requirement and the need, the requirement for consultation on the part of the minister.
All right, so Mr. Hawk, I'm going to just tweak something a little bit, because we've gone down. There were two possibilities: no duty to consult and a duty to consult, and we've just explored that. Now, the whole thing about this is fairness. Your ex parte duty, the principle of fairness, correct?
Yes, Mr. Your Honor.
Right.
Yes, Mr. Your Honor.
It is, I think, accepted that if the requirements of fairness are met in a factual matrix of any case, then there may be no duty to consult. That's why I asked you, what do you mean by consult? So if it is that the requirements of fairness were met in this case for the very reasons you have just given in response to whether these satisfy the duty to consult. In other words, the decision was not unfair, or it was fair because the minister had before him all, etc., etc. Then, I'm just trying to be very technical. Does that mean there was therefore no duty to consult in the circumstances of this case? There's a difference between that, it may be subtle, and saying there was a duty to consult, and what does that mean? And that duty was satisfied. I don't know if what I'm raising is a distinction without a difference or not, but what are your thoughts on that?
Your Honor, can I ask, inquire with your leave?
Sure.
If the intimation by Your Honors as to whether the notion of consultation, as we understand it here, is one, I know I said the issue of representations on paper, but I'm simply asking whether Your Honor is speaking to a physical meeting and consulting with the parties concerned, or Your Honor is talking general context?
No, well, that's the point. The point is, what does consultation mean? Consultation may not mean physical meeting face to face. It could be virtual, as we are meeting. We are consulting with you on what to do in this case. But it could also be through correspondence. Consultation is not governed by form, it's governed by substance. I want something slightly different. It is a distinction between a duty to consult and no duty to consult. What is the fundamental complaint? Unfair treatment?
Yes.
All right. If it is, and if there is fairness of treatment, then there may be no duty to consult. Isn't that what ex parte duty is saying?
Yes,
Yes, you agree?
I agree.
All right. So in this case on the facts, give me an order of priority. What's your highest position? Okay, you said no legitimate expectation, no express promise, that is unequivocal. We got that. Do you say there was no duty to consult because the requirements of fairness were met, ex parte duty? I'm not suggesting you should say that, I'm asking a question.
What I'm saying, Your Honor, and I don't want to confuse the court. I'm simply saying that the duty to consult was met on the part of the minister. In this case, just by means of what was put before him.
Okay. All right. Fair enough. Let's move on.
Obliged. Your Honors, the second issue which I wish to address very shortly is the issue raised by the Court of Appeal in its decision suggests that there seems to be on the part of the appellants complaints, allegations of grievances, and I think it was raised. There was an acrimonious relationship between the parties, and the Court of Appeal, and we submit, we want to agree with the Honorable Court that the applicant, the appellants, on the face of the evidence, seems to be prosecuting their grievances, private grievances, as between the various shareholders, the companies, as opposed to the issue, or transposing that issue rather, to one of a public law transgression on the part of the minister. And we say that because I accept that there was a time period, this matter took a little while, but what I want, what is our respectful submission, Your Honors, is that the appellants did not.
Mr. Hawk, I can't help myself. Did you say it took a little while?
Yes, please, Your Honor.
Thank you.
It took a little while.
I think, Justice Barrow, that's a euphemism that Mr. Hawk sometimes uses.
Took a little while. But Your Honors, the issue here is that the transgressions, they seek to transpose allegations and grievances in relation to private grievances into a public law transgression on the part of the minister. But what I'm respectfully submitted that I don't see on the face of the evidence, there was no action whatsoever taken on the part of the appellants in relation to the notion, and I'm using this in uplifted quotes, Your Honors, that the board, the Ogle Airport board, took a unanimous decision, albeit there was some recanting afterwards, but no action was taken against the Ogle Airport board and the part of the appellants during the course or prior to these proceedings or during the course of the currency of these matters.
But Mr. Hawk, I understood Mr. Kusun to be saying that it wasn't the Ogle Airport board that renamed the airport, and therefore the remedy that they are seeking, i.e. to have a proper consideration of the renaming of the airport, cannot be directed against the board. It has to be directed against the minister, because that is the public law official that took that decision. How do you respond to that?
I accept, Your Honor, that the ultimate decision was made by the minister, and if you want in the wider context, by the government. But the fact still remains, Your Honors, that in respect of the issues concerning the shareholders, it was the Oval Airport Inc. board who intimated to the government that there was a unanimous decision. In fact, when you look at clause 24 of the lease, the government really cannot act without the say-so of the board. And I'm simply saying, Your Honors.
But Mr. Hawk, you are not saying that because it was a unanimous request by the board that the minister could not disapprove. You're not saying that, huh?
I'm not saying that.
No, and so so it really doesn't really matter that. Of course, the minister could not change the name without a request from the board. But once there is a request, and the board can only request it, suggest it. But it's the approval of the minister that establishes the name change, correct?
I accept that, Your Honor.
And
Okay.
you're also willing to accept that not all the appellants were members of the board, are you not?
That is accepted.
Okay.
But sorry.
Yeah. So what did you want to address now?
I was simply making that point, that observation. I will move on from there.
Yeah. Are you going to insist that this is an academic matter, or
I wouldn't.
Should we leave that?
I wouldn't pursue that aspect of it. Clearly, because we're here, there are issues here and questions that the court would have asked me that would require some consideration by the court. So I will, for want of a better term, abandon that position.
Yes, and for as far as it has some academic aspects, the bench has two academic judges with us, so I suppose we can deal with that.
I'm guided, Your Honors. I'm guided. But Your Honors, I think the crux of this matter and the crux of this appeal, I don't want to belabor the point, would be the issues that would have been just teased out by the court, and the issue of whether in fact there was consultation by the minister. And I've put to you my submission in that regard, and I asked the court to so find that there was proper consultation in all the circumstances, and that having regard to that, the decision of the Court of Appeal was proper in the circumstances. Unless there are other issues that the court would wish me to address directly, those would be my respectful submissions.
This is something a little bit left field, perhaps, Mr. Hawk, but given that there are practical men and women here, I'm just wondering about going forward. Now, is there a possibility for a remedy that looks at providing the kind of consultation that the appellants are seeking outside of quashing the decision to rename and the order which was consequent on that? In a sense, that kind of remedy would be consistent with one view of what was said by Minister Patterson in his alleged interview with the Starbrook News. So I'm not sure this is being asked for or desired by the appellants, but I'm just curious, are there procedures in government which would at this stage, without quashing the name, renaming or the order, allow for additional consultation on that point without, as I said, having to undo what may have been done?
Your Honor, it's a very difficult question, I must admit. And I'm not trying to be facetious. I'm just thinking forward. Now there is a new government in place. Mr. Patterson is no longer the Minister of Public Works. Let me see if there's accepted a procedure that can work going forward, that can accommodate what the appellants are indicating. It may be that the new Minister of Public Works may have a different view. He may take into consideration different factors, and it will be difficult for me to answer that, but it may be that a different decision will be made. It may be that a decision might be taken to change the name, but I certainly think that a remedy could be made in order where at least if the court is, assuming the court is not satisfied, I wouldn't urge this upon the court if the court is not satisfied, that perhaps some level of consultation be had. But my position is that there was sufficient consultation. So technically my answer would be no to the question posed by Your Honor, because I think even if I were to consider what Your Honor is saying, it would pose a lot of policy difficulties and so on, having regard to the fact that there's a new administration in place in Guyana at the moment. Your Honor, that's the best answer I can give, and I'm not trying to be facetious.
No. Thank you. I appreciate that. Thank you very much, Mr. Hawk.
Thank you. Mr. Kisun, anything to reply at this point?
Yes, Your Honor. Just briefly. It's our respectful submission that the letter that was submitted by the appellants on November 17th, the one paragraph that was referred to in the letter that dealt with the issue of the airport renaming, among others, and the reading of that letter by the minister could not in itself be sufficient to satisfy the requirements of the duty to consult. And though his comments on the 10th of May could lead one to assume that he has considered something, there was nothing before him which he could have considered, because the review process which he recommended be started had not yet commenced substantively. And in that vein, I just wanted to point, Your Honor, to by contrast, what the facts and circumstances were in the Sati Bastio versus Gaisuko case, where there were substantial more interactions with the appellants in that manner, which led the court to the conclusion that factually the process of consultation had been adequate, and where the court said in paragraph 28 of the judgment that modern trends indicate that the consultation process embraces more than just affording an opportunity to express views and receive advice. It involves meaningful participation and overall fairness. And here we were not, the appellants were not afforded an opportunity to participate in any manner, because the designated mechanism to do so was abandoned. So the purpose of the article was to demonstrate evidentially that Mr. Patterson had made a decision, understanding that there was a process in train, and in so doing, acknowledging that the process had not yet been completed. Though the article may suggest that he considered something, what was submitted to him was not, in our respectful submission, sufficient to satisfy what is required as a matter of law for meaningful consultation.
Mr. Kisun, I need to take you up on the matter of the letter of the 17th. That is far from the only thing which was before the minister. There was a plethora of representations from everybody. I think each operator wrote the minister, and each of them made essentially the same point. I can give you the dates of the letters.
Your Honor, just to say that that letter, the contents of that letter, just raised awareness of the issue. It did not deal with the substantive issue.
But Mr. Kissoon, you're telling me about the purpose of the letter, and I'm telling you exactly the contrary. It is not the letter. I'm saying that there were probably 8 letters.
Yes, Your Honor, there were 8 identical letters written to alert the minister.
I read them, and they are not identical.
Well, forgive me, Your Honor, I say so colloquially, and I didn't mean to put it in that manner. But what those letters did not encompass the totality of the circumstances, and in any event would have predated what the minister undertook, the process that the minister undertook to be completed in order to enable him to arrive at his decision. So if it is that the minister recognized, which he did, that something more was required and undertook to embark upon that process, for him to have abandoned that process and then say, well, I've considered the material that I had, which would include the letters that you refer to, Justice Barrow. That in itself would show that he breached whatever promises or whatever conduct that he himself agreed to abide by. That would be our respectful submission.
And Mr. Kissoon, just so that you can correct me, because I may be going wrong, as I understand the interpretation to be placed on what he said in the newspaper article, he is saying that the review process will continue. A review process is in train. I have already made the decision to change the name. I have considered the representations which were made. I do not dismiss them. Some of them need to be considered, and I think the President opened by establishing the nexus between the renaming and the other complaints which the operators had, etc. So I think what I am looking at is the minister had, by the time of that article, made his decision to rename based upon, having considered the representations about unfairness, about the anti-competitive nature or impact of the proposed renaming. And he had not dismissed the anti-competitive concerns, and these would be addressed in the further review process. So I'm telling you that that is one interpretation which occurs to me. It is not that I'm wedded to it, but I share that with you in case you want to direct me to the contra review more strongly.
Certainly, Your Honor, we would say that to the contrary, that is a clear indication that he abandoned the consultation process before its conclusion, and accordingly ought not and could not, as a matter of law, had made the decision at that stage. And this was an express admission on his part that he has abandoned the consultation process without completing it. In other words, he only considered partially of what was before him, and the rest of the material he was yet to receive ought to have been received before he made his decision. And that is how we would urge the court to look at it. If there were so.
Soon, just in reply, Justice Barrow, are you completed? Yeah, just to, for my purposes, and if you can't do it now, maybe you can send us a note on it. Have you in your submission framed the 4 constituent requirements of consultation? Have you, or any, what have you framed? What are the requirements of consultation anywhere?
We simply refer to the principles that were established by the court in Sati Basteo, not to, so as not to repeat what we thought were trade principles.
Okay, all right.
But based on this.
Yeah. So what do you say? I think how many are there? 4 principles. What are they?
That's correct, Your Honor. There ought to be. This is paragraph 27 of the Sati Basteo judgment adopting the gunning principles in the gunning case. Consultation when the proposals are still at the formative stage. Adequate information on which to respond, adequate time in which to respond, and a conscientious consideration by an authority to the consultation.
Right.
And
So that's your framework. In other words, I'm just trying to clarify your analysis and submissions that the requirement of consultation was not met. You will pass that through this lens, right? In other words, when you take the evidence, you pass it through these 4 principles, and therefore you come up and say, well, okay, great. If you invited us to analyze it through these 4 principles, and you say the conclusion is these were not satisfied. I just want to be clear that that's what you're telling us.
Yes, Your Honor. And against the gloss which qualified these principles is explaining them to mean that it involves meaningful participation and overall fairness, and that these could not have been met in the framework which the minister himself proposed for them to be.
Right. Okay, I'm just clarifying. The last thing I just want to ask you about, just to get your response to, I asked Mr. Hawke about it, and I did not of you clearly, I think. The duty to consult arises, I'm again using ex parte duty as the sort of template, the baseline case, that the duty to consult arises out of the principle of fairness. Agreed?
Yes, well, that's one
right.
way.
Right. So the underpinning requirement is fairness. There are some instances in which the duty to consult does not arise. That does not mean that there is unfairness. It simply means that the requirements of fairness have been otherwise met, because the fundamental requirement is, in administrative law, the process must be fair. Agreed?
Yes.
Do you agree with that?
Yes, Your Honor.
All right. Question, and it's just for your response for the record. If, on the facts, the minister had all of the relevant information that he needed to make a decision on name change, and to do so fairly, would a duty to consult have arisen in this case?
As a matter
consult in the context of the four-stage framework you've set out, the gun-in principle.
Yeah. Yes, Your Honor. It will be our respectful submission that it would, because factually we are a group of appellants who are directly affected by the minister's decision. We are a closed group, and accordingly proceed against the backdrop of a known factual situation that extends beyond this case. We would submit that the notion of fairness would require a lot more than just a conscientious decision, but rather consultation, meaningful consultation in one form or another.
Okay. Thank you.
There's nothing further, Your Honor. Thank you very much for your time, and good to see you all.
Thank you very much. Let me see. I think we will, of course, reserve our judgment and give it not a little, but a lot of thought, I suppose. You will get an announcement when we are ready to deliver the judgment. Madam Deputy Registrar, you can close off.
Thank you very much, Honourable Mr. Justice Witt. Thank you very much, Honourable Judges. Thank you very much, Counsel. And thank you, staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Goodbye.
That was good.
Here we go.